Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Napasa, and today we are going to dive into another very interesting topic. But before that, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. And it's real pleasure to have you join us. You can also participate in this by commenting in whichever platform you're watching, so that your questions are addressed. And maybe even if you have anything to share with regard to the topic or whatever you're experiencing out there in the US, it'll be really nice to know. So thank you so much for joining. And it this topic is in the mind of so many folks out there. What are the best alternatives to the H-1B visa for your career in the US? Many changes are happening with regard to the H-1B, and today we are just going to discuss about all of that. And I'm really very excited to have none other than our guest, who is an who's a great immigration attorney, and she is Attorney Prashanthi Reddy, a leading expert in immigration law. And we are really happy to have you join us, Prashanthi. Thank you so much.
Thanks for having me.
So, yes, today we are going to discuss on this topic. And Prashanthi, what can folks out there expect from this webinar today?
Well, we're talking about alternatives to the H1, and the reason we're talking about this is for twofold. One is there's a lot of talk about what's going to happen with the H1B program, so we just want people to not be so anxious because they know that there are alternatives out there. So to give them some alternatives to the H1B program, I'm not saying it'll go away, but even if it diminishes in some way, it's always good to have some alternatives. um, the second reason we're doing H1B alternatives is because the cap has been reached and we can't file any further H1s until you can do registrations in March, but you can't file H1s until October. So there's a gap of more than 6 months. So it's good to know what your alternatives are if you need to work in the US before that.
Absolutely. And we are excited about this whole webinar because there's so much to discuss about. And most of the time, H-1B is given a lot of attention to, but, the US immigration system really offers a lot more different options, variable options for folks out there. So you're in the right place if you were wondering, if not H1B, then what? So, yeah, I think without further ado, we should go ahead with the first question that I have for you, Prashanthi, is that what are the key advantages of applying for a cap exempt H-1B visa, and how is it different from the standard H-1B lottery process?
So, depending on who your employer is, you might be eligible for cap exempt H1. The companies that are eligible for cap exempt H1s are employers who are institutions of higher education, nonprofit related to or affiliated to an institution of higher education, or a nonprofit research organization, or a government research organization. Let's break it up a little bit. An institution of higher education is basically a college or a university and not a school. And now, nonprofit related or affiliated to an institution of higher education is, say, a hospital that is a teaching hospital that is affiliated to a university, has a contract or is in some other way related or affiliated to a university, like a medical school, maybe, whereby medical students can gain practical knowledge in that university, right? So there's an agreement between the two institutions. So that's a nonprofit related or affiliated to a higher education institution. A nonprofit research organization, so not just a research organization, but a nonprofit, set up as a nonprofit, or a government research organization that is owned by the government. In all these cases, if you're directly working for these employers, of course, you can be cap exempt. But also, if you're indirectly working for them, for example, you're working for a consulting company and they're contracting you out to one of these organizations, then if you're working for them, one of these organizations as a client, also then you can file for a cap exempt H-1B. So recently also in the upcoming H-1B regulations, um, they have broadened the scope of who is a cap exempt H-1B organization, and they have said that it's not necessary that that's the only work that they should be performing. That is research work for in the case of a research organization. But they could be working other work, doing other work, but as long as the research work is the fundamental work that is being performed by the organization. So they've broadened the scope, whereby a few more organizations or employers might now become qualified for a cap exempt H1.
So there you go, friends. That is what cap exempt H1 means, and that's another option for you too. I mean, to not get into the lottery, but see where you fit in, of course. And apart from that, Prashanti, I think we would also like to discuss if you can explain the L1 visa, for multinational managers and executives out there who are working, and what are the eligibility criteria for transferring to the US?
Yes, so another good type of work visa is uh, L1, which allows multinational companies who have a presence abroad and who have a company in the US as well to transfer their employees from their overseas office to the US office. This is a good option generally for foreign employers um, seeking to boost their presence in the US, opening branches in the US, maybe coming as an owner of the company to set up office in the US, or you could be sending your employees as well. The added benefit of an L1 is also the fact that the dependents can work automatically. So they can get an L2, and the L2 by itself, you don't have to file any EAD or any additional work authorization, you can automatically work. So that's what an L1 is. With reference to the criteria, the employee or the owner or whoever it is that is entering into the US on an L1 has to be working, had to have been working in the foreign company as a multinational executive or as a manager. So they should have held an executive or a manager position for at least a period of 1 year uh, in their foreign organization. Then the second criteria is that they should be continue to be working as an executive or a manager in the US. So you have to show the job description, job duties, um, and proof that they've previously worked as an executive. So documentary evidence as well. It could be like board meetings. It could be contracts that they're signing. It could be executive decision documents. It could be email correspondence with their employees showing that they're working in an executive or managerial position. So it could be any of those documents in addition to the job description. So the third criteria, so we have that they should have worked in a multinational executive position. They should be working in a multinational executive position moving forward in the US company. And the third is there should be a relationship between the US company and the foreign company. And the relationship should be that of a parent, a subsidiary, an associate, or a branch office. A parent and subsidiary happens, for example, if one company owns another company, or it could be that one individual owns a majority share in both companies. It could be an associate if there are more than one owner and all the owners own an exact same share in both the foreign company and the US company. So these are the different relationships that are acceptable for an L1. In addition to that, I think the fourth point would be that they should be conducting uh, business, a viable business in the foreign entity as well as the US entity should show that they have business activities, that they are actually conducting business. So for that, you'll have to submit documentary evidence again to show business, bank accounts, tax returns, contracts. There is, of course, one exception. If you are a US company that is a startup, that is, you've incorporated less than a year ago, then you don't really have to show business activity documents or tax returns, obviously, because you're less than a year old. You don't have to show financial documents, but you have to show that the company has the ability to do business in the following year. And for that, you can submit a business plan to show what your vision is, what your market is, and what you expect to make financially. So that's a little bit about the L1. You also have to show, sorry, go ahead, Nipasa.
No, I was just saying, very interesting, and it's a great option as well. Very well explained. Also about the eligibility criteria. The giving out points. I think it's very, very clear the way you're explaining. You can carry on.
Thank you, thank you. Um, so I mean, you might get a request for further evidence on an L1. Usually, individual L1s are more difficult to get approved, but there is something called a blanket L1, where if you are a company of a certain size and have a certain volume of business and you have um, you know, uh, tax returns showing certain amount for the sales, then you can, meaning a big company, then you can file for a blanket. Blankets are much easier to get approved because you don't have to file for each employee. You just have to file once, and then each employee just goes to the consulate with their documentation, and the consulate then looks at the documents and approves or denies it. So
Okay,
that's a
for the
blanket.
blanket, is there like a limit, like minimum or maximum, or it can be any number?
It's any number. It just has to make sense to the consulate, and of course, they have the ability to deny any case if they see that too many are being filed,
Mhm.
based on the size of the company and with the need of the company. So that there's always that checks and balances that happen at the consulate. Um, so people don't file thousands of applications, but
Yes.
yes, there is no actual limit by law as to the number of L1 blanket cases that you can file. So, if you are a small business, then you would file an individual L1. And of course, there is the L1B, of course, which is L1A is executives and managers. L1B is specialized knowledge. So, a lot of companies like
Okay.
TCS and these big companies file a lot of L1Bs. It's almost like a H1. You have to show that you have specialized knowledge of the product or processes, and it's
Mhm.
difficult to train someone in the US to understand those products or those processes in your company. So you have to justify what specialized knowledge that employee has, and also why it's difficult to train the person to get that kind of specialized knowledge. So that's an L1B. The disadvantages of an L1B is it's versus an L1A is an L1A is EB1 goes into EB1 green card category as a multinational executive. So the visa numbers, the green card numbers are much better for EB1, whether it be India or any other country. Whereas for an L2, L1B, you have to file EB2, and EB2 means that you have to file a labor certification, get an I-140, and then file a 485. For the L1A, the other advantage is not only is it EB1, but also you don't have to file a labor certification. You can directly file an I-140. So there are obviously, as you can see, advantages of L1A versus L1B, but there are only a certain number of L1As that can be filed, because how many executives or managers will a company have, right? But whereas people with specialized knowledge, there can be many, many people. So that's why companies usually file more L1Bs than L1As. So that's your L1 option.
Thank you so much, Prashanti, for the detailed explanation and explaining it so well. And I would also like to greet our friends who have joined us on YouTube, LinkedIn, and on even on X. Thank you so much, folks. And hi to Imran, Ishita, Deepti for your comments, and Rag as well. Welcome back once again. Um, Well, I think we can take rugs because it's very related, but L1 blanket has more rejections than L1 individual at the consulate level. Is that true, Prashanti?
No, I don't think it is, because for the it's just that there's more volume of L1 blankets being filed. That's why you might think that when compared to individual L1s. Individual L1s, they're not that many filed. And then remember that um, USCIS first approves the L1 and then they go to the consulate. For an L1 blanket, USCIS is not really looking at the documentation for individual L1 blankets. That the whole thing is being done by the consulate. After getting the approval, the blanket approval, then you continue, just going to the consulate with individual applications for the L1 blanket. So it might seem like that, but um, I don't
It's
think
not really
L1
the case.
blanket has more rejections. I think L1 individual has more rejections.
So there you go, Rag. Um, we also have Pedujo saying, "Hi, when H1B 2026 registration starts?"
In March. We don't know when exactly as yet, but it could be any time between March 10th and March 20th. That's the usual time that they started, but it's not the
Oh,
same day every year. So we have to wait and see. We'll probably know in February.
all right. So once we know, Pedujo, we are going to update in our channel. Please check it out and don't forget to subscribe to us. All right. So, Prashanti, let's get back to our questions. And before I have my question, I want to ask you what is an OPT and what is an OPT extension and what is STEM? And then we can go on to take up the question.
So basically, the alternatives, I guess, what is STEM OPT, and what is CPT, I
OPT
guess, right?
extension.
Yeah,
Yes.
OPT extension and CPT. So these are all uh, practical training options that you get if you are a student. So the post completion OPT is anyone who has completed a program that is at least of 9 months. You get post completion optional practical training for 1 year, meaning you get an EAD, you have to file a I-765, you get an EAD for 1 year, whereby you can work for any company, related company to your the major that you've studied. OPT extension is if you majored in a STEM field, then you get an additional extension of your optional practical training for 2 years. So you get a total of 3 years optional practical training. In order to do either, your company has to be e-verified, so they have to get onto the e-verify website, log in and e-verify you, register for that site. So you have to be e-verified, and there for the post completion OPT, that is the 1 year OPT that you initially get, it doesn't have to be paid employment, it can be unpaid as well. But for the STEM OPT employment, it has to be paid employment. There's certain amount of time that you need not work. There's 90 days, I believe, of time that you can not work, but the rest of the time you have to. It doesn't have to be full time, it has to be 20 hours a week. So that's a little bit about STEM OPT and post completion OPT. CPT is curricular practical training that is usually given to students. They can take permission to get CPT while they're still going to school. OPT is after completion of school, CPT is while they're still going to school. This eligibility for CPT depends on the school and the program that they have. Some allow CPT on day one because they have an executive type program where uh, practical training is important as part of their coursework. It goes side by side with classroom education. So they do allow CPT. So that's CPT and that's what OPT is.
All right. Thank you, Prashanti, for telling us what they are and defining them, telling us about the little differences as well. Now, going on to the question, so how does the OPT extension for STEM graduates work, and what are the best strategies, for securing long-term employment in the US through OPT? I think we've already covered the first, so you can take up the second bit.
Right. So I guess the best strategy, and this is something that students are already doing, Unfortunately, because there's no guarantee of getting selected in the CAP, and also because of the uncertainty with reference to the H-1B program. A lot of students are depending on OPT and CPT. And I mean, it's important that you register as soon as you finish your F1 and not wait until your STEM OPT gets over. So that's one way of maximizing your STEM OPT. Register for H1B every single year. So you have three chances of getting picked, and you might get picked during one of those times. Now, if they don't get picked, a lot of students then opt for continuing their studies and they take up a new program. Maybe they do another master's or they do a PhD course, and then they work on CPT if the school allows them to work on CPT. So there's no gap between their OPT employment and then moving to a CPT. And you can continue on CPT as long as you're in school. And if you have, especially if you've done a PhD and you don't do another master's program, then you can get a new OPT period, STEM as well as regular OPT period for another 3 years, right? So you can theoretically, since a PhD is like 7 years or 5 years or 7 years, depending on the subject, continue working for a long period of time by remaining a student and then working simultaneously. So these are a few practical tips or options available if you want to continue on a OPT or CPT. Another option is also, of course, while you are a student, to apply for a green card. Then, especially if you either are EB1 or you're EB2 or EB3 but don't belong to India or China, it's possible you might get the green card and you might be able to transition directly from an OPT CPT to a green card situation. But of course, there is some issue with reference to dual intent on an F1. So you on an F1, you have to show that you intend to return to your home country. If you file an immigrant petition, it shows that you intend to immigrate, and that's not allowed on an F1. So as long as you're not filing anything on the F1, going to USCIS to ask for any benefit, also applying for a visa, then it might be okay pursuing the green card option simultaneously with your F1.
Okay, okay. And what about students who are transitioning from being a student to probably an H1 job? Do you have any updates like an extension?
So yeah, for them, you have something called cap gap. And the good thing is, as per the new rule, the cap gap has extended until April of the next year. So what is
Next year.
cap gap? So there's an artificial extension of status for all students who've applied for change of status from an F1 to a H1. As long as it's not consular processing and it's change of status, then that H1B cap gap rule applies, which means that whatever your status was at the time of filing your H1, that status continues and is going to continue as of the new regulation until April of the next
Next year.
following year. So you can, even if there is a delay in your H1 getting approved, you continue to be in that same status that you were when you first filed, even though that status might have actually expired while your H1 was pending.
So it extended by almost 6 months, right? Earlier it was, I think,
Correct.
October.
Correct. Yes.
All right. Thank you, Prashanti. And those were great updates. And let's go on to our next question. And that is if you can tell us what are the specific benefits, and even the requirements for the TN for Canadian and Mexican professionals under the USMCA trade agreement.
So for Canadian and Mexican nationals, there is an additional work visa called the TN visa. And it's available to all jobs that are designated occupations as per NAFTA. So there is a document available where they have a list of jobs and the educational experience requirement for those jobs. So as long as you meet those requirements, you should be good. TN, the advantage of TN is it's not subject to cap. You can file it at any time. There is no limited number of applications that uh, that are, it's unlimited number of applications that can be filed. So it never happens that the TN visas applications run out. Also, for people who are in Canada, they don't even have to apply the TN with the USCIS. They can automatically apply at the port of entry. They can take the entire application to the port of entry and then just apply there. They don't even have to apply with USCIS, and it's a very simple process. And they don't have to go for a visa because they're just applying at the port of entry. They don't need a visa. For Mexican nationals, I believe you don't have to apply at USCIS, but you have to go for a visa. So it's a slightly different for Canadian and Mexican employees. But if you're in the country, then and you want to apply for a TN, then you'll have to apply with USCIS. The documentation and the process is different. It's more detailed. You have to actually fill out forms. There are 129 forms for the TN. So it's almost like filing a H1. So if you're in the country, the process is harder and it goes to USCIS, then it has to face USCIS scrutiny. But if you're outside the country, then you're just going directly to the port of entry, especially if you're a Canadian national, and applying for the TN there. So it's much faster and easier to get. So that's a little bit about the TN.
Okay, thank you so much, Prashanti, for taking that up. And we have a question, but I think we will address it a little later. And this is from our viewers. So let's go on to the next, and that is the e visas, the E1 and E2. So if you could also tell us what they are, and even the E2 treaty trader and investor visas, and how can foreign entrepreneurs, leverage them to start a business in the US.
So when we first talk about the E3, since we're in the E category, the
Yes.
E3 is another non-immigrant category only for Australian nationals. So these are all country specific. Since we're talking about Canada and Mexico, Australia has another visa which is available only to them. It's called E3. Very similar to the H1B. You have to show specialty occupation. Again, you don't have to file anything with USCIS. You can go directly to the consulate and apply at the consulate for an E3. So that's an E3 criteria is exactly the same, specialty occupation, which means that you have to show that a bachelor's degree is required in a
Mhm.
specific field for the job that you're doing. Another country specific visa is H1B1. This is for Singapore and Chile, and they have 10,000. There is a cap, but it's a separate cap of 10,000 and usually not used up. So usually these Singapore and Chile H1B ones can be filed throughout the year. So that's an advantage if you belong to any of those countries: Mexico, Canada, Singapore, Chile, Australia. They have their own visas. Coming to the E1 and E2, this is also country specific, not available for India, for example, but it's available for many, many countries. And there is a list of E1, D2, treaty trader, treaty investor countries. So look up that list and see if you are a national of that country, then you can definitely apply. The E1
Okay.
is the treaty trader visa, is suitable for foreign nationals that have multinational employers, meaning employers that have businesses in more than one country, and they are wanting to transfer them to the US, and the company has significant trade. They are a trading company between the foreign and the US entities. There is significant trade. So it could be an employee, it could be the owner of the company who is being moved. That person has to show that they have the skills which are essential for the operations of the trading. Dependents are eligible again to work in the US. So that's the E1, which is the treaty trader. The treaty investor is again allows foreign nationals to invest
Mhm.
a substantial amount of money in the US. And this, again, the E2 beneficiary could be the owner of the company or could be an employee of the company. The E2 visa allows that person to manage and direct the investment that is being made in the US. And the amount of investment generally varies. It depends on the type of industry. It's a kind of a proportionality test, which means that you have to show what the investment is required for your type of business, and you have to show that you have made that kind of investment, and you have to show that that money is being used by that company. So you have to show the paper trail and the money trail.
Okay.
Um, so some companies could require a large investment because they have infrastructure costs, and some companies, like consulting companies, don't require any investment except for, maybe leasing an office and hiring a few employees. Again, dependent E2s are eligible to work just as dependent E1s are. So that's the advantage of the E2 as well as the E1.
Okay. And talking about there are more visas, and we are going to talk more friends. But I think since we spoke about the TN visa, I we had a question from one of our viewers, and we want to know what is your comment. So, control, if you can display that, please. So, Canada's known own are. Could you zoom in a bit, please? Or
We
maybe
can't
let me.
see.
Yeah. So, yeah, Canada's own are also victims of the dollar greedy Indian agents who lied about Canadian PR to Indians. Due to severe lack of homes and entry jobs in Canada, partially due to Indian students creatively swarming all post secondary schools, then vast majority fighting for PR versus returning home. Regardless of what cause, they chose or qualifications extra etc. Many asking for asylum. Canada PR has never been tuition purchasable. What do you have to say on that?
It's a comment that somebody has made. They were worried about excessive immigration in Canada, maybe. I am not a Canadian immigration attorney, but I mean, there's, scope for all kinds of opinions, and this is one of them. That, there's one school of thought, even in the US, where they think that jobs are being taken away by the immigrants coming from outside the country, but it's been proven through research, etc., that jobs are actually created by immigrants coming to the US rather than taken away. Because if there's one qualified person, then three other people are hired.
Hired, right.
Under that that one qualified person creates additional jobs. So I mean, scope for opinion. So that's just a different opinion that it's good to hear.
Right. And talking about, I mean, America, and you know that it's a land of immigrants. So, how common are immigrants than Americans? Like, out of 10 people, how many would be Americans and how many would be
Uh,
immigrants?
I don't I don't have that number. Um,
Okay.
it depends on the where the person is located, where the geography of it. In
Yes.
the cities and urban areas, you'll find more immigrants.
Hmm.
Like New York City has many immigrants. The
Right.
schools, if you look at, um, have a lot of immigrants when compared to even the local population. But
Hmm.
then again, what is to say who is local and who is an immigrant, right? If
Yes.
you are a US citizen, you're a US citizen. You're not an immigrant anymore. You might have
Yes.
a different skin color and you might look different, but that doesn't mean you're not American. So
Yes.
what is your
All Americans
definition
in
of,
the end.
yeah, so it depends on what your definition is. If it's strictly um, your immigration status, then it's difficult to say because there are a lot of US citizens also in America that are there for many generations, right?
So
So,
true. True.
right. So, if you're talking about non-immigrants, then yes, there are quite a few, especially in the cities and in the places where there's work available.
Hmm.
Uh, there are quite a few.
All right. Okay, let's take up Pedujo. Hi, Pedujo. Yes, thank you for coming back. And he has a question. So for
Rakesh.
L1A, yeah, for L1A visa, employer mandatorily files for green card, or any requirement criteria is for their for okay. Are there any requirement criteria for an employee, or differs from company to company for filing green card?
For L1A visa,
I think the question is, does the employer mandatorily files for green card, or is there a different requirement or criterias, for their
oh,
employee?
okay, got it. So, it's not necessary that your Rakesh, that your employer should file for the green card. They may not want to file for the green card and send you back. So there is no mandatory requirement that anybody file your green card for you. That is completely dependent on the employer whether they want to continue you working for them. If they want you to continue, then obviously they have to, because the L1 expires in 6 years, and there's no extensions beyond the 6 year, 7 years beyond the 7 years. So if they want you, they to keep you, they have to file. Otherwise, they have to let you go and send you back to whichever country you come from. The requirements are the same for filing for EB1, no matter what type of company it is.
Mhm.
Requirements are pretty much the same. The type of documents that you submit might differ, because some documents you might not have those kind of documents because of the type of business that you do, and you have to explain that to the US and USCIS, and that should be fine. So, other than the types of documents that you submit, which might borderline be different, the requirements are really the same.
Okay. Thank you so much, Prashanti, for taking this up, and I hope you've got your answer, Pedojo. Yeah. Let's go on with some other categories of visas that could be alternatives, if not the H1. So let's head on with the EB categories. And if you can tell us about the EB5, which is an investor visa. So what is the process, for obtaining a green card through this EB5 investment program? And how can foreign nationals benefit from it in terms of employment and immigration status?
So EB5 is an investor visa program whereby you invest a certain amount of money in the US, and that investment amount keeps changing. Now minimum is 900, I think, and maximum is 1.2 if I'm not mistaken. Um, but if you are investing in a regional center, then it's the lesser amount. If you're investing in a targeted employment area, meaning a high unemployment area, then it's at the lower amount. Otherwise, you have to pay the regular amount. You have to invest in a business, and you have to employ 10 full time people. Uh, if you're investing in a regional center, you're investing as a passive investor. So the regional center will then show that they have hired X number of people to satisfy the requirement. So you could either start your own business, be an individual investor, or you could invest passively into a regional center. So that there are two ways of getting the EB5. The EB5 processing time is very lengthy, unfortunately, for about 4 years just to process. That's why might not be a good option if you are thinking short term of coming to the US. But if it's a more long term plan, then definitely an EB5 would be a good idea. Get if you get the approval once you send out all the documents about 4 years later, then you can come in on an EB5. Then after 2 years, you apply for removing of conditions, and that could take again a few years. So you'll get a temporary green card to start off with which you enter the US. Then you get a permanent green card after uh, the removing of conditions period is over, and after you file the application and it gets approved. So it could be another 2-3 years for that to get approved. Also, something to keep in mind is the visa number availability. The visa green card numbers are not always available. So even if your application gets approved, you might have to wait for some time before you can come to the US on the green card, because you have to be the consulate will then keep the file with them and notify you and call you for an interview once the green card number is actually available. So that's a little bit about EB5.
Very interesting. Thank you so much, Prashanti, for taking that up. And I think we will take up the view questions from our viewers. But before that, I just want you to tell us about the EB2 NIW. Is it a good option for foreign professionals with a master's degree, and how does it impact, employment authorization?
So that's basically all the green card applications depend on the priority date as to whether they're good options or not. EB1 would be the best because the priority dates move the fastest. EB2 followed by EB2 and EB3. Um, you can file your green card application and come directly on a green card. Um, this, of course, you so they basically the employer will file your labor certification, will file your I-140, and then it goes to NVC, National Visa Center, and then goes to the consulate, and then you get an immigrant visa petition approved at the consulate, and then you come in on a green card and get the actual card in the mail once you come into the country. So that's how the green card, direct green card thing works for employment based.
Okay.
As I said, for EB1, might make more sense for Indian and Chinese nationals to do it because it's a few years wait. For EB2 and EB3, absolutely doesn't make sense for India and China because it's over 20 years of wait. But for other countries, EB2 and EB3 national interest waiver or EB2 regular advanced degree holders might make sense uh, to do directly a green card, right? So that's definitely an option, an alternative to the H-1B if you want to work in the US and get be able to permanently stay in the US. It's much better than a H-1B. It's just the time taken to for this to happen is much longer than what it would take to get a H-1 approved. The national interest waiver is still EB2. It's not EB1. So it's not a big advantage doing a national interest waiver, but the advantage is if you don't have an employer or you have an employer that's not willing to sponsor your green card, then filing it yourself. A national interest waiver is a self petitioned green card, so you don't need an employer. So that is definitely an advantage if you don't have an employer to do an NIW. Otherwise, it is EB2. So from a green card priority date point of view, it's not much of an advantage over the regular employment based EB2 application. But in EB1, extraordinary ability, researcher category, multinational executive, like we talked about the L1, those are all EB1 and they are advantages because the EB1 extraordinary ability is again, you don't need an employer. The research category, you do need an employer. And multinational executive, of course, you don't need an employer because that's L1 based. Same criteria as an L1. So that's a rundown of employment based green cards and how they can help you uh, circumvent the H-1B. In what circumstances that can be used as a viable alternative.
Well, I do hope that there'll be good news for Indian nationals and folks from China as well. So that they have good news. I mean, all the time they check out, it's all backlogs and 20 years wait, 12 years wait, long time, long wait times. And we also have Sri Ramakrishnan making comments about the green card caps, right? So I really hope things are going to happen better. Let's just hope for the best. Let's take some comments now, and let's start off with Imran's first. So I'm currently on an F1 visa, and my OPT period is ending soon. Since I wasn't picked for the H1B, is there a way to extend my stay and continue working for my current employer legally?
Yes, you could. If you're not picked, you can continue. OPT is ending, so then you'd have to transfer to another school and go to a school which allows you CPT day one. It is a little dicey right now. USCIS does send RFEs, but haven't seen denials based on the fact that someone took a day one CPT as long as we're able to show that CPT was a requirement was part of the curriculum, was a
Mhm.
requirement as part of the curriculum. As long as we're able to show that, I haven't seen denials, but we don't know what the future has to hold. So I would be careful doing a day one CPT. USCIS has always been warning against this, but if you have no other option, then that's one way to proceed.
Okay. All right, let's take up some Facebook questions and then we can come back to our questions here. Control, if you can display, please. All right. So meanwhile, we can take up Ishita's comment, saying, "I'm a Canadian citizen working remotely for a U.S. company. Would the TN visa be better alternatives to the H-1B for me? And are there any specific qualifications or limitations I should know about?"
So she's a Canadian citizen working remotely for a US company. The TN visa be a better alternative for a H1 than a H1? Are there any? Yeah, so TN might be a better option because there's no cap for a TN, but you have to see if there is a TN, the job that you're doing is available under the TN visa, and if you have the qualifications that are required under the
Mhm.
TN visa. So you have to check those two things to make sure that you're eligible for a TN. Then TN is definitely a better option than a H1.
Okay. Ishita, all the best, and I hope you figure out what can be the best option for you. But TN definitely sounds good. Let's go on. Control now. Let's take up this next one. This is from Facebook. So, hi, my initial H-1B was expiring on September 30th. Employer put in an extension a few days before under premium processing. I received an RFE for maintenance of status since I got laid off by the end client, and my employer did not run payroll for 2 months. Now the employer told me they respond to the RFE deadline for it is January 10th already. And what are my options now? I'm really worried. Can I convert to B1 or F1 visa?
Um, you can file for a B1 or F1 visa before your denial. If you are expecting a denial, it would be prudent to file now while your status is still pending. Get a receipt, and then say if the H1 gets approved, then you can just cancel your B1 or F1 application, withdraw it. So that's one way of doing it. Uh, if you are on the payroll, not on the payroll for 2 months, then you might be able to use the 60 days grace period as a valid legitimate excuse when responding to the RFE. And hopefully, your employer has responded properly with all the proper documentation. So you might still get an approval because you can use the 60 days grace. Provided, of course, they have brought it to their attention, to USCIS's attention.
Right. Thank you, Prashanti, for taking this up. Now let's go on to our next question and let's have it on the screen, please, Control. So, hi all, I'm switching from my current employer to new employer. Please let me know if it's odd mandatory to take the I-140 approval document from the current employer. It's a consultancy, so I'm not sure if they will give.
It's a good idea to get the copy of the approval so that you can, moving forward, apply for further extensions on your H1. If they're not giving it, then you can file, request it under a FOIA. They don't give the approval exactly, but they give you a document that will be sufficient for you to then port your priority date or apply for an extension beyond 6 years.
Okay. Next question. Thank you so much, Prashanti, for taking that up. We have this one and saying this is an anonymous participant. Hi, I dropped my documents for H-1B stamping and I received 221G to attend in-person interview and attend the interview at Chennai consulate and it got approved. My question is, will passport get delivered to the selected location or do we need to take any action from our end?
Uh, yeah, you'll have to, they'll let you know where to pick up your passport. So the good thing is that you got it approved. Now it's just waiting for you to get for the passport, and they'll let you know where you can come and pick it up.
Okay. Congratulations to our anonymous participant and all the best. So let's go on to our next one, Prashanti. And this is, hi everyone. I have a counselor H-1B interview on 16th of this month, and Dependent visa, that's tomorrow. And dependent visas for my wife and two children, 4 years and 2 years. Total of four applicants, including me. Do I have to take my kids also for the counselor interview, or just a photocopy of theirs are enough? Please guide me on this. Thanks.
You have to take them in person. Whoever is applying for a visa has to go in person, attend the, go to the booth and show that they are present. So everyone has to go.
Okay. All the best to you and your family out there. Thank you so much for your question. And thank you, Prashanti, for taking this up. Let's go on to our next question. Um, Hi, everyone. It's been 12 days. My H-1B visa has been approved but not been issued yet. Do I need to worry about anything? Also, I call the headline number. They just say it's in final processing and nothing else. Is there anything else I can do? Please advise. Thanks.
For the visa, I mean, not much you can do other than sending them emails, following up with them. If it's taking much longer, then contact your local congressman to see if um, they can help. They usually have a hotline to the consulates. They can send an email as well.
Okay. All right. Thank you so much again, Prashanti, for taking this up. I hope that was helpful. Now, let's go on to our next. Hi, everyone. My initial OPT expired on 1st of October 2025. Sorry, on 10th of January 2025. And due to SEVP portal maintenance, I didn't get a chance to apply for STEM OPT. And I applied for STEM OPT on the 13th of January 2025. Does this create any problem with my status? If any RFE, how to mitigate that?
I'm not sure what the SCVP portal maintenance is and why you are not able to apply on time. But if you applied after time, unless you have a legitimate reason to have not applied on time and it is something beyond your control, for example, the portal was not working um, on the day that I don't know why you would wait until the last minute anyway, unless it was not working for a few days.
Mhm.
You could give that as a reason as long as you have proof that the portal completely was down and it was not just some problem from your end.
Okay. So the SEVP portal I just checked, it is only students who have OPT approved can use this portal.
Correct.
All right. So thank you so much. And yes, why wait till the end? I think it's always best to keep some buffer period, right, Prashanti? How long do you,
Yeah, just
how,
in
I
case.
mean, yes. And
Like
how
a
long do
week
you
before
suggest?
at least. At least
Okay,
a week before, if you're filing online. And if you're filing by mail, then longer because then you can't know what will happen with postal service. There may be a delay
right,
in delivery, etc.
right.
At least a
All
month
right.
before if it's by mail.
Yes, a month before would be best, I think also. Thank you so much, Prashanti. All right, let's go on to our next one. This is I had my visa interview back on 16th of January at the Dubai consulate. 6th of January, so sorry, 6th of January. And I was given 221G PIMS petition, PIMS petition. I waited for 1 week and the status is still in the refused state. I asked for my passport from the embassy and I'm traveling to my home country. After receiving my passport back from the embassy, they provided me with another 221 white slip with admin processing. How many days does it take to change my status?
Um Administrative processing can take a long time. It sometimes takes 6 months to a year, also, depending on what they're looking at. They're basically looking at information maybe about your employer, if this is a H1, uh, the investigating documentation that you submitted, maybe calling the client, calling the employer, investigating documentation from your home country. It could be anything. So that usually takes time, and sometimes I mean, it can get approved as fast as a few weeks to a month, and sometimes it takes 6 months to a year.
Okay, that's interesting. And now this next one. This is my H1B transfer pending for more than 5 months from Vermont Center. Actually, it's crossed processing timeline and even raised e-requests. Please advise on my case.
Nothing much can be done if your visa is pending. You just have to wait. H-1B transfer is pending. Okay, so then change to premium processing. Why wouldn't you upgrade it to premium processing if it's taking longer than expected? That's the best solution that I can think about.
Okay. All right.
Have
Thank you
we
so much. Yeah.
have we done all the questions of people present, Dipasa? I think we have, right?
Yes. No, I think we
Just want to
have
make
one
sure.
more. This is Deepti's
Let's
question.
do
So
that.
let's take it up. Yes. Oh, we have Deepti. Yes. Let's take up Gotham's first. I've heard about the EB2 NIW visa as an alternative to the H1B visa for skilled workers. Yes, we took that up. And how does this work? And is it realistic for someone like me with expertise but no major awards or publications?
It may not be because national interest waiver is basically in the interests of the United States. They are giving you a green card. So you have to be pretty top notch superhero for them to give you a green card. And as to you can't just be run of the mill and ordinary, right? You have to be extraordinary, though that's not the criteria. It's exceptional. Um Again, it differs from officer to officer. Some officers are more stricter. This is very subjective. Uh, their criteria to decide whether to give the green card is very subjective. Though they have some objective criteria that they use, I have noticed that there is a vast difference between one application and the other. So if I mean, but generally there has to be some awards or publications need not be there because that's just means that's for researchers. So if you're not a researcher, but there should be at least some major awards or achievements that you have done and not just had tons of years of experience because anybody that has come to a certain age will have that experience that you do.
Okay.
So you have to show within the people that have that experience why you are better, why you're in the top 10% or 1%.
Right. So, Gautam, I think you will definitely need an expert attorney, and why not attorney Prashanti Reddy? Maybe tell more about yourself, your case, and she could tell you where you could fit in best. And you can also call her on this number 212-354-1010, and you can leave her a mail even at prashanti at reddyesq.com, and go visit www.reddyesq.com to get to know more about attorney Prashanti Reddy. And this goes to all the folks out there. You can always have a one on one consultation with her and tell her more about your case. And yes, let's take up this next one. This could be the last one from our viewer, Dipti. And she's asking, my H1B visa application has been in refused status since April 2024, marked as under administrative processing. I haven't received updates or explanations since. What steps can I take to resolve this or expedite the process? Should I be doing anything while waiting?
Not much that you can do while waiting. Unfortunately, sometimes it happens, and this is going to be the new normal under the new administration, unfortunately, because they're going to refuse many more visas and they put them into administrative processing. As I again said, that they are looking into something and they have limited resources to do all this secondary inspection kind of work. It's difficult to say when you will get it, but it seems to have been a long time, almost a year. Um you can file lawsuit, a mandamus, to force the. I don't know if you can do that with the consulate. I think you can to force the consulate to give a decision. Either way, you could approach your local congressman to ask them to write a letter or send an email to the consulate. That helps. And you can follow up also with the consulate, which I'm sure you must have been doing. But those are the options available for you. There's also something called the Ombudsman's Office, but they deal, I think, more with USCIS issues than with consular office. So consulate issues. So I think those are your options for now.
All right, all right. Thank you so much, Prashanti, and all the very best, Deepti. I hope that you can figure out how to get a status update on your case. And I think with this, it's a wrap, Prashanti. Thank you so much for patiently taking all our questions, all the questions from our viewers as well. It was a great one, very insightful one so far and enlightening one. Thank you for sharing your expertise and guidance on the different alternatives uh, for on an H1B visa, sorry. So if you have anything more to share before we leave to wrap the session up, it'll be great.
Um, yeah, with reference to the H1B alternatives, that's the topic that we had today. Um, I would say I think we've covered everything. Can't think of anything else to say. I think we've covered all the alternatives that they are. The only thing is maybe family-based green cards is another alternative. So if you have an immediate relative who is a US citizen or a permanent resident, you can definitely use that as an additional alternative to getting a H1.
Mhm.
And I don't see much change with reference to availability of H1B numbers this year. It's going to be the same as last year, and your chances of being able to get approved under the lottery are the same as they were last year. So keep that in mind and make alternative arrangements uh, if necessary.
All right. Thank you so much, Prashanti, once again, for joining us today. And it was a great session. So, folks out there, if you really found this, helpful and insightful, you resonated with the content today, if you were looking for what are your options apart from the H1B, then please don't forget to like, share, and also subscribe to our channel. We are Immigration and Jobs Talk Show, and we are on YouTube, LinkedIn, Facebook, and on X. And yes, you can contact Attorney Prashanti Reddy also, and her phone number, once again, I could say is 212-354-1010. Don't forget to also email her if you need any help with regard to having an expert to tell you what to do next with your status, with your case, or even in your career. So you can best email her at prashanti@reddyesq.com, and also go visit www.reddyesq.com. And yes, tell us more about yourself. Maybe you could email me and I could forward the same. So my email address is nipa@staffingme.com. And you can also call me or WhatsApp me on this number, 408-335-6444. Thank you once again, folks. Thank you for joining us. Have a great day ahead and stay tuned on Immigration and Jobs Talk Show.